course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law, because the law matters. A better understanding of the law puts you in a better position to decide how to help yourself, your family, and at times your business. As we present various topics, as we also suggest, there are times that you may want to handle some issues yourself. Our goal is to help you. Actually, to help you save time, money, and to achieve the best possible results, especially when you end up connecting with a lawyer. We want for you to be prepared, and you will be better prepared, so will the lawyer who you select. As always, we want to welcome and thank once again Attorney David Bizarre from the Bizarre & Associates law firm in East Providence, who continues to weigh in on the topics that we discuss, as well as give us some interesting anecdotes along the way. So today, real estate, buying, selling, financing, and everything in between, as much as we can cover during this time segment. Not surprisingly, there are so many issues that can cause trouble along the way. Realizing the substantial amount of money that's involved in transactions, it's fertile ground for legal issues. So we would like to help you be prepared for that. Property disputes and non-disclosure agreements and zoning and title and contracts. That's why we have our legal eagle here. So, David, let's begin with just a basic understanding of what is real estate law. What does it consist of?
So it can consist of a lot of things. I thought for today's show you wanted to discuss buying and selling primarily residential property.
Okay.
But as an overview, it can be commercial property, it can be leases in property, it can be a lot of different things. Estate planning can involve dealing with real estate and titling property correctly, either in a trust or otherwise. So anything to do with real property, we consider real estate law.
So at times we say people can handle some things themselves. If you are contemplating a purchase, a residential property, let's start with the basics of that. Do you need a lawyer? When do you need an attorney? When do you engage them? And usually people will reach out for an agent. Where do the roles connect? Where do they part?
Do you need a lawyer if you're buying property? Unless you know how to do a title search to make sure you have clear title.
What does that mean?
So what happens is when somebody buys property, they want to make sure the person selling them the property owns the property and that there are no liens or any issues with the title to the property. So what would happen is generally you would hire an attorney who would go and look at the chain of the history of the title, the chain of title as they call it, and make sure that there haven't been any breaks in the chain of title to the current owner, to make sure there are no liens or mortgages or undischarged mortgages that were already paid on the property, and to make sure that it's what we would call a clean title, so that the person selling you the property has the right to sell you the property. And if you're borrowing money, a mortgage from a bank, the bank's going to require title insurance to make sure that the attorney did the search correctly, but more importantly, that there aren't any undisclosed issues that need to be insured so that nobody's coming back with a valid claim against the property, which would either be a cloud on the title or some other issue with the ownership of the property.
So to help our viewers, attorneys do titles. There are also other companies that do title searches as well. Bona fide, reasonable, legitimate?
So there are some title insurance companies that may have the ability to do the title search and to do a closing. It's been a long discussed issue as to whether that's the practice of law or not. There are certain things that a title company can do, and there are certain things they can't do because they've stepped over the line and are now operating in the same arena as a lawyer that is properly licensed, and if they're not attorneys, they're not licensed to give advice, for example. So there is some statutory law and rulings that allow different folks to do different things customarily done by non-attorneys along the way, but it's really a matter of what your preference is in terms of whether you need advice or you just want someone to do the paperwork.
What should you ask someone who says, I can handle this all of it, I'm not a lawyer, I'm a title search company, contractor, whatever. What should you ask them about the degree or the extent to which they can follow through without it causing trouble? Is it a state-by-state issue, or how does that work?
It's probably a state-by-state issue, but it would seem to me in almost any state, they can't give you advice. So you can't call them and ask them legal questions because they can't give legal advice. So if you feel like you may need legal advice, hire an attorney. If you're not worried about what you're doing and you don't have any legal questions, you're not worried about certain issues with the neighbors or other issues that may have come up that you're aware of, then if there's a concern and you need to get advice, you need to have an attorney. If you just want someone to be able to do all the paperwork, to do a closing and give you a title insurance, you can use a title company.
So you touched on a couple of things. In that whole entire process of buying a house, at what points do you handle each step of the process, and how do you work with, whenever it's necessary, an agent who might be involved?
All right, so are we buying or selling?
We're going to be buying. We're buying
All right.
first.
So
we'll do selling afterwards.
We're buying a house. So if you're buying a house, you can either go through the process on your own by going to open houses and looking at listings that you can find and going through that process and making offers. Usually there'll be an agent for the seller, but as the buyer, you may want to have your own agent. In Rhode Island, the seller pays the transaction fee, so it's not really costing you any money, and you'll have an expert available to you to advise what the proper offer should be, what the market looks like, whether or not you need to bid beyond the asking price if you're in a bidding situation, which we had many of a few years ago, last year even, or whether or not there are any other issues that you need to be concerned with about having an inspector and all of those other types of things that usually a buyer might want to know about going into buying a piece of property.
What about such issues as zoning issues, or I'm just trying to think about other things that repairs were done, were supposed to be done, might not have been done?
Yeah, so as a buyer, there's some help you can get from the agent, and that would be, do we need an inspection? Can we waive the inspection? Do we need a mortgage contingency clause? Can we waive the mortgage contingency clause? Things that a buyer agent is familiar with and has dealt with and is competent to deal with. When it comes to zoning, they may be able to do an overview of the zoning, but that's one of those things where, depending on what you were trying to do, you may need legal advice. And so if you want to buy a house and you think you want to use it as a 3-family house and you don't know if it's zoned as a single-family house or what you're allowed to do, the agent might be able to help you with that, but maybe not. The title insurance company really shouldn't be giving you advice on that. That's something where you're probably best off talking to an attorney.
And let's just follow up on that again for a moment. It looks like it's a 2-family house, could be a 3-family house. Is it zoned for it? Or maybe it was 1, you might want to make it 2. In other words, you might be interested in it becoming an investment property, and does it need zoning changes? Agent or attorney?
Attorney. Once you're talking about changing zoning or making sure that something is allowed to be done in a particular zone, you really want to talk to an attorney about that.
And at closing, we need an attorney. If I have an attorney, do I need to be there too?
So are you the buyer or the seller?
I'm going to stay as the buyer
Okay.
for this set of transactions.
All right. As the buyer, you need to be there because, are you taking out a mortgage?
Probably.
Yeah. There's a
Let's go
lot of
with that.
paperwork that a buyer's going to have to sign at a closing. So the agent who sold the property for that buyer You said you're the buyer.
I'm the buyer.
So if you're there as the buyer, yes, you have mortgage paperwork and all of that. Your agent cannot sign those papers for you. You have to sign them.
And if I am paying cash for it, I don't have a mortgage, do I still need to be there? Can the agent take care of it at the closing with you?
It would seem to me that even if you're paying cash, you might want to be there to go through the settlement sheet to know exactly what the numbers are, to make sure there's no hidden fees that you're paying for that you weren't aware of, and a number of other issues that may come up at that closing transaction. So could you send someone in your place with power of attorney or other things of that nature? Maybe, but it's not advisable.
If I have a lawyer with me and I am that buyer, that paperwork at closing, it is the lawyer, it is the attorney's responsibility to look at those other line items that I might not necessarily be aware of and point them out. Is that one of your roles as an attorney representing the buyer?
Yes, and the seller as well, because there's two lines, one for the buyer and one for the seller, and there's a lot of different things that can go on those lines that can be complicated if you don't have an attorney, such as they prorate the taxes. How are the taxes prorated? What is it? Is it a calendar year, a fiscal year? It depends on the city or town oftentimes. So those are complicated calculations that you really need somebody probably at the closing to explain to you, unless you're a regular buyer or seller of real estate and understand how they're prorated.
Good to know. If, again, I'm the buyer, I just purchased a home, the seller agreed to certain repairs, they weren't done, is that okay at the time of closing? Suppose they aren't done later. Do I need the agent? Do I need the lawyer? And does it have to be litigated?
Well, if you have certain agreements that haven't been done by the time of the closing, it's an issue. There's ways of resolving those issues, but it's not something you can say, oh, no problem, we'll take care of it after the closing, because the closing is sort of the termination of the agency or agreement or transaction. And so if there were supposed to be repairs done and they haven't been done, and there's an agreement on what the cost is, what I would do as an attorney is say, escrow the money for those repairs. And then if the repairs are made by the other side, the money can be released. Or the money can be used by the buyer to make the repairs, and whatever is not used, released to the seller.
Okay, and right prior to that closing, agent's responsibility to do a walk through the house to make sure that everything they thought was going to be repaired was there when done, and everything that they thought was included in that purchase, I don't know, perhaps the appliances. Agent's responsibility, not the attorney's?
It's not the attorney's responsibility, but if I'm the buyer going through the property with the agent, I would be much more comfortable being there than just having my agent go through.
Okay. And what other things come to your mind as tips or things that we should be aware of that a lawyer would pick up on that perhaps the average buyer would not?
Well, certain adjustments that might need to be made. Certainly, as we talked about taxes, there could be oil in the oil tank that should have been done. The final readings for utilities, water, electric need to be done. Then the more important than those things, because the agent usually will handle all of those things, more importantly, the lawyer will make sure that the adjustments are made correctly, but also you're looking at any legal issues with the transaction. Are there any liens that haven't been discharged that should have been discharged? For example, oftentimes mortgages were paid off, but the discharge of the mortgage was never filed. So that's an issue that an attorney will often handle for you, to contact the bank that didn't discharge the mortgage, or even more complicated, the successor in interest to whoever bought the mortgage and didn't discharge it. Or we've had situations where the company that has the mortgage, or the bank or whatever, is no longer in business, and now there's another process for getting that discharged.
So you mentioned mortgage a moment ago. Perhaps this is a good time to speak about the financing issue. Again, I'm the buyer. You're working with the buyer. Mostly you have to go to a bank yourself and find out what your limit might be in terms of buying your ceiling for buying a house. Where does a lawyer come into play regarding financing?
A lawyer doesn't usually come into play at all when you're picking what company you want to use, because you've usually already picked that before you bought the house, because what you're sort of referencing is pre-approval. Because if you're a buyer, you want to go to properties when you're making offers to buy the property with a pre-approval in hand, so your agent can tell the other agent, this is a good buyer, you don't have to worry about this, they're already pre-approved. And that's done usually before you've signed a purchase and sales agreement and end up in a lawyer's office.
We're not really ready to talk about commercial, but would a lawyer be more involved if there were commercial real estate investments and the planning for financing there, or is that something an accountant usually handles?
A lawyer could be involved in that. It depends on the relationship between your client and the lawyer, whether or not they have an agent that they deal with or a bank that they're already hooked up with.
Okay, let's talk about the seller then. When does a seller need to enlist the services of an attorney?
So as a seller, you have certain responsibilities. And again, that varies state by state, but in Rhode Island, the seller has to deliver good title at the closing, and usually in the form of a warranty deed. Although if it's an executor of an estate, it's an executor's deed. So it depends on who the seller actually is, but you have the responsibility ultimately of delivering a deed that transfers the property correctly. So the doing or drafting of the deed is your responsibility. Usually you want an attorney to do that. There are certain other things that need to be done, such as a residency affidavit. So in Rhode Island, if you're a Rhode Island resident, you file a form at the closing that it's an affidavit that says you live in Rhode Island. If you're not a Rhode Island resident, then you have to file a form with the Division of Taxation, which either sets forth how much needs to be withheld from the sale, or if there's no gain, why there's no gain, and that there's nothing that needs to be withheld.
And that's something that your attorney would need to know about and take care of
before the closing.
If you are a seller and there are defects in your home that you know of, well, you'd have to have an inspection. There may be others that you didn't know of that you're about to find out. But the point being, if there are defects in the home, how does a lawyer help in how that is disclosed and what is disclosed?
Usually that is done if you have an agent in forms that you fill out when you're listing the property, and it's called a disclosure form, and you go through and you list any known defects and make sure that you explain what they are and how they've been addressed.
Does every defect have to be listed?
If you know about it, you should list it. If it's a latent defect, as you say, that you don't know about, and it's going to come out in an inspection when somebody goes through, that's oftentimes when people will deal with those things, as you said, agree to repair, give back some money, however you're going to deal with it.
Would a lawyer be the ideal person to handle what that negotiation might be, or is that something that buyer, seller, agent representatives will deal with?
It's usually done agent to agent. That's why, as both a buyer and a seller, you're usually better off having an agent for things of that nature. I have been involved in closings where the issues haven't been resolved because maybe they've come up since the initial negotiation and subsequent to the inspection, where we've had to deal with things at closing. But usually it's done beforehand. And
now you're representing the seller. Does the seller need to be at the closing if you, as their attorney, are taking care of business?
Well, it's an interesting situation. Pre-pandemic or post-pandemic?
Let's go with post-pandemic.
Okay. So oftentimes, these closings are done in two stages, where the buyer will go to the buyer's attorney and the seller will go to the seller's attorney, and then the seller's attorney will deliver the documents to the buyer's attorney for that closing. It has changed a little bit again, where we're sometimes now back in the same room, but it's very different from the pre-pandemic days.
Which do you prefer?
I kind of like being able just to deliver the package to the buyer's attorney if I'm representing the seller, because they can come in. There's a lot less paperwork for us to do. We go through it, we make sure everything's signed, we go through the numbers, and then we can deliver it. So it's less time for me to be out of the office.
Makes sense. Let's talk about what often people discuss as the as-is sale from the buyer's and then the seller's perspective. If you are representing the buyer as they're about to acquire as-is property, what's your role in that?
So again, depends where they hire me within the role, but what I would explain to a buyer buying it as is what you're really doing is you're waiving the inspections. So if you buy the property and there's no condition for inspections that allow you to go in and bring an inspector and make changes or get out of the deal based on the inspection, then it's on you. So oftentimes what people do is they have either some knowledge of real estate and property and conditions, and they'll walk through and they'll look at it before they make an offer with waiving the inspections. And if they do that, then that's a defect found later is not something that they can raise.
And what if you are representing the seller, and so you know that there might be some issues with it, that's why it's being sold as is, maybe it's personal, they can't take care of the things that need to be repaired for whatever reason. How do you work with the seller then in that situation?
There's often many reasons why a seller will sell as is. Sometimes it's an executor of an estate where they don't live in the property, haven't been in the property. It might have been an older parent who wasn't able to really keep up with the maintenance of the property, and so they don't want to deal with those issues. So the only thing they need to know is they're probably going to be taking less money than if they had fixed some of the problems and disclosed whatever they knew and allowed for inspections.
So while an agent will be working with the seller and an attorney might be working with the seller, who's in the better position, or do you work together to make it most successful, or what the best possible option is for that seller? How does that process play out, David?
Yeah, so we have different roles, but often we work together. So if I am representing a seller and I have an agent, or I should say my seller has an agent who's representing them in the sale, we often are in contact with each other discussing different issues and things that either the lawyer might have a little more expertise on or the agent has questions about. So it's usually a team effort.
And what about financing situations when it comes to the seller, meaning that at times perhaps a seller is willing to help finance it? Do you have a role in that? Where do you see that there might be a role for that, and how does that process play out?
That's actually a very important role for the attorney at that point in time. There's a lot of documents that need to be drafted and drafted correctly and dealt with correctly. So if the seller is taking back what we used to call in the day paper, giving a mortgage, is it a first mortgage or a second mortgage? And is it, what is the interest rate? What are the terms of the loan? So a promissory note has to be drafted that reflects the proper terms of the loan the seller is giving to the buyer. And then a mortgage has to be drafted to secure that loan on the property. And again, where is it being secured? Are you in second place, meaning your second mortgage, or are you the primary lender, so you have the first mortgage?
What happens if it's first? What happens if it's second? How does that play out? How does it change?
So you have less security if you're the second mortgage. If there's a first mortgage and the buyer defaults on that first mortgage, that wipes your mortgage off the map, so to speak, if they foreclose.
Any protection against that?
Yeah, you can go to the sale, the foreclosures auction, and buy it.
Doesn't sound like the ideal situation to have to deal with. What do you find in these transactions that end up being the most litigious? I mean, it seems to me that there may be many things that can be resolved prior to heading to the courtroom. What are the common things that you can handle and most often encounter, David?
So oftentimes it's one of the parties backs out of the deal, and that's a bigger problem. And the purchase and sales agreement usually has the answer to what can happen if one or the other party backs out. So if the seller backs out, there may be language in the agreement that the buyer has the right to sue for specific performance, which means that the buyer has the right to sue the seller to force the sale on the terms as laid out in the purchase and sales agreement. If the buyer backs out, generally the penalty is the forfeiture of the deposit. So it's one of the things that both either the agent or the attorney needs to make sure is negotiated and in the purchase and sales agreement, so that if you're representing the seller, the buyer has put up a big enough deposit to make backing out reasonable for your protection.
When the seller has taken a deposit, if he, for whatever reason, changes his mind, is that ever written into the contract? Perhaps the seller wants to sell the house, but it's sort of contingent upon whether or not he bought something else, or needs the float time. What does float mean? Needs the mortgage bridge time.
Right.
How does that work, David?
So what happens, and what you're describing, a situation where I'm selling my property, but I've made it contingent on being able to buy and close another property, or reverse, the buyer is buying the property, but it's contingent on them selling their property and closing on their property. So any contingency that's written into the agreement, if that contingency is met, so example, or not met, I have a mortgage contingency and I'm unable to get the mortgage as the buyer, I'm entitled to get my money back as long as I followed the terms of the agreement, which usually there's a date. And I have to give notice that I've done all reasonable steps to get a mortgage, but for whatever reason it was denied. It could be denied for a number of reasons, including the property didn't appraise high enough. So given whatever the situation is for the contingency, if it's met, then the property, the purchase and sales agreement will deal with how you deal with the property.
And who needs to watch over the purchase and sales agreement? Both the buyer and the seller? Is that a key area for a lawyer to come into play?
You could have a lawyer to do that, but usually the agent, if you have an agent, is dealing with, all right, the contingency for the mortgage is next week, and they'll be in touch with the other agent. Because remember, agents really want the transaction to take place.
Of course.
Have you gotten the approval on the mortgage? We need to know that. And so they're usually on top of that. If you have a lawyer involved at that point in time, the lawyer, if there's no agent involved, may be involved in making sure all the I's are dotted and the T's are crossed.
And what about in general financing issues on either side of the transaction? Where does a lawyer most key when it comes to financing? Is it only in residential? I mean, is it only in commercial, or is there really a key need when it comes to financing for residential?
Well, there can be. Certainly, as we said, if you're self-financing, if the seller is taking back the mortgage, then you definitely need a lawyer involved in that. But there's certainly room for an attorney to be giving advice as it goes along and explaining to you at the closing. Oftentimes what we'll do is we'll explain the documents to you that you're signing that are memorializing the promissory note and the mortgage and what it means.
Okay. With the short amount of time left, short sales, handled just and only by the agent, need an attorney, or no?
Or both.
Both.
Yeah, it depends on the circumstances and what side of that you're on.
So where is it more critical that you have a lawyer?
Well, certainly you might want to have a lawyer if you don't have an agent to negotiate if you're buying property in that situation. So you have documentation of what you're buying and what the deal is, and that whatever is not getting paid off is being discharged.
Good to know. We hope that this has been helpful to you in considering your options, whether buyer or seller, and perhaps the next time we'll be discussing a little bit more about the commercial side of life. Thank you for tuning into The Law Matters. As we say, it matters to you.